let me welcome Dr. Dominic Ayene, former Deputy Attorney General. Also, Ace Ankama is on the line on Zoom. Thank you, gentlemen, for making time to join us.
Thank you very much, Samson, for having us.
Good to see you, Ace.
Thanks, Samson.
Great.
Hi, Dominic.
All right.
Yeah.
Right. So let's start this way. The question of legal education in Ghana and how it's perhaps is getting worse by judging from the quality of lawyers and also quality of judgments. And Dominic Ayene has been a chief advocate on the quality of judgment for a period now. Even the president himself has also had to complain about the quality of judgment from the court. The only time we get to shout and cry is when students who have done their LLB are sitting exams to qualify for the Ghana School of Law, and there is a mass failure. Now, this report, what do you make of it? Can we say that the problem is actually not from the teachers at the Ghana School of Law failing the students, but from the place where they are churned out in the first place? Let's begin with Ace.
Well, I don't think that the response will be that respectfully that simplistic.
Mm-hmm.
What this report shows, and what this report shows is that our legal training, our legal education is not fit for purpose. It's not fit for purpose. And so the blame is not on students or lecturers. The blame is the entire system. Yeah. And if anything at all, this calls for a root and stem review of our legal training, legal education, and for there to be changes. Now, the changes, although appear massive, are achievable. They are doable with not that much expense. I see that there are a lot of recommendations, but they seem to be institute-focused. This school must do this school must do that. My view is that it goes beyond that we need some root, branch, and stem reformation or reform of our legal education and legal training system. And that will be something that maybe we'll get into going ahead. But my preliminary comment is that this tells us that our legal education system is not fit for purpose. But let me add,
that's a very serious statement.
A lot of the things that are being spotted, yes, a lot of the issues that are being raised, I have encountered them in different levels at different stages of legal education since I started teaching fully, let's say, from 1996. These have manifested themselves in various forms along the line. And I think that right now, everything has come to a head. And this gives us a great, although delayed, opportunity to fix this. But my view, having read this and from what I know, is that our legal training and legal education system is not fit for purpose.
So let's start interrogating the report this way. 8 of the 15 teachers at the University of Cape Coast Law Faculty are not qualified to teach law. And this is even by the National Accreditation Board standard, not the General Legal Council standard. You have the report replete with lack of books, libraries. Now, as a teacher, tell us the place of books, libraries in training to become a lawyer and being trained by teachers who are not qualified, including at places where the dean of the faculty has no training or background in law.
Well, if the deanship is just, Dominic is laughing, if the deanship is just an administrative position, then anybody can be the chief administrative officer, of any facility. But if the deanship involves taking decisions on the content of tuition, the placement of lecturers, the qualification of lecturers, and the dean does not have any training in law, it's symptomatic of the problem that we have. I will say the report is public consumption. So I do not really want to mention the names of schools and what their problems and the problems that have been identified that exist. Samson, basic tools for legal education. Former teacher, so stop calling me a teacher. I'm a former teacher. One.
Of course, I don't forget some 10, 11 years ago, I couldn't sit in your class without reading tons of books.
Yeah, because if you didn't read, I'd call you a dummy, right?
Yes.
All right. Now, there are two basic tools, and Dominic can confirm this. Is that one, the quality and quantity of the faculty, and the same quality and quantity of the library. They're the two fundamental building blocks for any legal education problem. The quality and quantity, let's say quantity and quality of the faculty and quantity and quality of the library. Let's look at the faculty. So here we are looking at the personnel, the teachers. One, how many do you have for the courses you're running? Because ideally you would need a lecturer and a couple of tutorial assistants to help handle tutorials for each course. So one, the quantity. So if you are teaching 15 courses, you are looking at 45, 50 staff, teaching staff to teach 15 courses, roughly. Now, so that's quantity. Two, what's the quality of the teaching staff? Now, on that, you are required, the University of Ghana standard is a terminal degree. Now, that's a very interesting point because while the LLB in Ghana is not a terminal degree, and even the Master of Laws is not considered terminal, the JD from the US is considered terminal. And so in the US, once you have a first degree and you do the Juris Doctor, the JD, which is really our law, but let's say a post-grad law, it is considered terminal. And so people like Obama taught in unis without ever doing a Master of Laws. In fact, Dominic will tell you that the Americans themselves hardly ever do the Master of Laws because their JD is considered terminal. So what do we mean by a terminal degree? If somebody comes in from America with a JD, is that considered terminal or we don't consider it terminal? There are definitional issues to look at, but the issue is the quality of the people who are teaching. And as this report shows, there are many people who are teaching even without the master's qualification, which is not even considered terminal. But I want to quickly move to issues as to how to resolve these. We'll come to that. So there's the quality of the faculty. Is the faculty researching? And the best proof of research are the papers that are coming out. Are the lecturers producing texts in their domain? If I'm teaching contract law, do I have writing on contract law that I'm updating every year, which is a standard tool for teaching the students? On account of having seen these operating elsewhere, you find that in many schools, for example, in the US, the material they are using is material produced by the school, by the lecturers. And so you open to page 25, and we are having the lectures. So there's the issue of the quality of the teaching. I used to have a joke when I taught law that a lecture in Ghana is when the lecture notes leave the notebook of the lecturer and appear in the notebook of the student without going through the head of either of them. I tried to start teaching in Ghana without dictating lecture notes. It almost led to a rebellion. That is how we do it here. Please just go and read and let them write, and they'll pass the exam and go. So first is the quality of the faculty. Secondly, the quantity of the library. How many books does the library have? In some jurisdictions, libraries are measured by how many kilometers of books they have, not number of books. The library is measured by the kilometers of books that they have, right? I was seeing books on Ghana in Canada that I didn't have to use when I was doing my LLB in Ghana. So the quantity of the library, and two, the quality, what is in it? I am finding out that there's a faculty of law teaching law in Ghana without a full complement of Ghana law reports. Now, at that point, you want to tear out your hair. Who is being shortchanged? That's why I say that.
When you say without a full complement, when you say without a full complement, what do you mean? Because I know that there is one particular one that had only two of them.
Well, if it's two, it's still without the full compliment. I'm trying very hard to be polite. Stop stop pushing me into being impolite. Yes, they had two. But even when we get to that, and we'll talk about this, Samson, I don't think we have enough time to deal with this. Look, the most recent Ghana law report is 2015, 2016. I think so. Which means that even if it's 2018, there are 2 years of evolution. And you and me and Dominic are aware of the nature of our Supreme Court today. Literally, law is changing on a daily basis. And so it is possible that the law that the lecturer is teaching based on the reported case is no longer good law.
Yes.
I'll give you an example. I was writing an article recently on pre-incorporation contract, and I went through Ghana law report and saw an authority, Kumi versus New World Investment, a high court decision. And so I went through the process of putting it in. Then I just had the premonition. Why don't you check your, I call it my junk, where I just collect decisions and throw away. And I checked, and the decision I was citing had been repealed. They're not repealed, had been overturned on appeal. And the appeal judgment has not been reported. So I would have gone out there and completely embarrassed myself. So it is not only the institutions that are not fit for purpose. The entire legal training system is not fit for purpose.
Okay.
In 2020, when almost every high court has its judgment typed before it is read, how long can it take to upload this on an indexed hypertext database on the internet? You tell me.
Okay.
We've come so far that the judgments actually appear in soft copy.
Right.
So it's a 3-second transfer uploading onto a website, and every lawyer in Ghana has it. So we'll come to deal with this.
Right. So hold on there for me. Hold on there for me. And I'll come to pick Dominic's minds on some of the issues that are coming up, including complete lack of tutorials. How do you train a lawyer without tutorials? Let's go to the Ashanti region now and get some quick update on the primaries there. Ohiming Tavia joins us. Hello, Ohiming.
Hello, Samson.
Yes. So what's happening in Fijasi?
Yes, thank you for the opportunity. A while ago, we were called to a scene here at the Fijasi MPP office at polling station, and we were told that an agent of one of the aspiring candidates, the lawyer Sami Adom Apia, tried to prevent a delegate from casting his ballot. So this resulted in a free-for-all fight between him and then the delegate who came to cast his ballot. And it attracted the attention of the police and military team here, who came to the rescue and picked this particular agent up. We are told he is Achiano. That is his only name that we picked from the electoral officers here. Let's get some information from the presiding officer, Kwesi Nkansa Boatin, who witnessed the situation here. Thanks for the opportunity, Mr. Nkansa. So can you explain to us what exactly happened here?
Yeah, one of the voters came to cast his vote. Then the name is in the register, all right. He's coordinator for one of the electoral areas. And then the agent said he will not allow him to cast his vote. Meanwhile, while we will go through the process, he was about to put the ballot into the ballot box. And he tried to prevent him from casting the vote. That's brought the incidents of routes and other things.
So did they exchange blows or what?
Yeah, it nearly resulted into an exchange of blows, but by the time intervention of the prison officers, and then there was a military police pass, and then they came to calm the situation. They took the agent away.
How did this affect the voting process here at the MPP office?
Oh, for now, since we started, there has not been any incident. Apart from just what happened just around 9:20 thereabouts. Nothing has happened.
Okay, so something the agent for one of the aspirants, Sami Adomapia, is currently in police custody. I must say it drew a large crowd to this particular polling station. A lot of people gathered here to catch a glimpse, and even at the police station where I checked, lots of the crowd had gathered there to also witness it.
And Kwame is contesting who?
Yes, in the Afijase constituency, Kwame Adom Apia is coming up against the incumbent, Dr. Nana Ayu FCA, the MP for Afijase. Right.
Okay, thank you very much, Ohiming Tewia, for that update. And we understand that this particular agent of the aspirant has been arrested. And you may have heard earlier also, we told you about the situation where the lawyer had been beaten with blood from his mouth. And we are hearing of spots of these sort of fights completely throwing away the ability to observe social distancing and to protect themselves from catching COVID-19. So let's return to the issue of legal education and what's been found from this joint assessment by the National Accreditation Board and the General Legal Council, and published under the authority and hand of the Chief Justice, who also chairs the General Legal Council. Now, Dominic, and I introduced you from a certain perspective because there are many lawyers, there are many judges who have been excited about this crusade you began some years ago. And I remember how loudly you echoed it at the conference in KNUST in front of Georgina Wood, Chief Justice at the time, when Anas had exposed the rot in the system. So, first, what do you make of the report?
Thank you very much, Samson. I think His Lordship, the Chief Justice, must be commended highly for this initiative, of undertaking the inspection and monitoring of law schools generally, and then also, and more importantly, for publishing the report. Something I must say that this is not the first time that this kind of inspection has been done. Of course, not with the General Legal Council itself taking part. But I do remember my own professor, Professor Kumado, led a team, I think in the early 90s, to the KNUST when that school, the university wanted to establish a law faculty. And he came back and wrote a very scathing report about the state of affairs as far as the KNUST was concerned and their preparedness for establishing a law faculty. I think people didn't take it kindly and thought that at the time he wanted to entrench the monopoly of the University of Ghana, Faculty of Law, being himself a lecturer at that faculty. But I think what Professor Kumado did probably set the standard for what we are seeing today, which the Chief Justice, has, picked up, so well. So I want to commend His Lordship, the Chief Justice, for this initiative. I have had personal conversations with him, and I think he has a very progressive attitude towards legal reform. And as Ace has rightly pointed out, as himself an experienced lawyer and a teacher, there is the need for a holistic approach to the reform. Any piecemeal approach will not work. If we are looking at a piecemeal approach that says that a law faculty A doesn't have what it takes to train, right, and law faculty B has what it takes to train, we will probably end up, having this conversation maybe a decade down the line. We need to have a very holistic approach to the issue of legal education reform. Samson, if you ask me, any system of legal education must deliver three things, okay? Or if you want, it must have inherent in it three things. First, it must be able to deliver on theories of law. All right, students must be able to analyze, have the analytical ability to understand legal principles and legal concepts and so on and so forth. So theory is one. Then, of course, the ethics of the profession, and then, of course, lawyering skills. All right. Now, I'm not saying this in any order of importance, but the faculties by nature, are the ones that give students the grounding to be able to build upon, their skills and knowledge about the law.
So anytime, that's the basis where anytime we got to the law school, from the LLB to the law school to study the professional course, the lecturers will always quote BJ Darocha, and say that your knowledge of the substantive law is irrebuttably presumed.
Irrebuttably presumed.
Presumed, yes.
But
all right.
in the current circumstance, you can't say so.
Presumption. Right. So that irrebuttable presumption is based upon the knowledge that you have been, fully tutored. You have been properly tutored in the legal, precepts, the principles of law, and so on and so forth at the faculty level. Right. So, for instance, if you are doing conveyancing, it is presumed that you have the knowledge of land law. All right. So basic concepts of land law should not be the starting point of the professional legal education. They have to now build upon that in teaching you conveyancing, which entails how you draft, and operationalize, land documents, and ensure that they properly conform to the legal principles of land law. So the point is that if you have a system that cannot deliver on all three, right, that is the theory, the ethics, and then the lawyering skills, then you are in serious trouble, because the products that you put onto the market, all right, the market for legal services, will not be fit, for purpose as Ace has rightly put it.
Right.
All right. So we must carefully think about a holistic approach to the reform of legal education if we want it done in a manner that will conduce to public good, as far as lawyering is concerned.
So what do we say about the National Accreditation Board itself? Because from this report, we find, for example, that the Central University, its Kumasi campus, was being operated without accreditation. We have students at the King's University College themselves discovering that there was some poor quality and complaining about it.
Okay, Samson, so the problem is, I had some little experience, again, working with Professor Kumado on accreditation. The problem is that when a university has been accredited, all right, it's been accredited to run a number of courses. So it makes an application to the National Accreditation Board, for its establishment as a university to run certain courses. And usually they will in the application for accreditation, indicate the number of courses that, they want to run, the course content, their human resources, their material resources, and so on and so forth, right? But the fact that you have been accredited as a university does not necessarily mean that you can run every conceivable course on the planet. So if you want to run a law course, you then have to apply to the National Accreditation Board for accreditation to run that course. And usually, because it does not have the internal expertise in vetting some of these applications, the National Accreditation Board will then refer the accreditation application to experienced, professors like Professor Kumado to vet and then approve. So Central University's problem didn't come to me as a surprise, because if they were given the accreditation to run a law course, they presumed that they could set up, that program as an offshoot of their law faculty in Kumasi. But that is not something that is allowed under accreditation, because if you are going to establish another school in, Kumasi to run the programs, okay, it means that you have to go back to the national accreditation for them to vet everything, with respect to the setting up of that school before you do it. So I was, really, really not surprised that that has happened, because most of the schools often assume that once they are accredited to run university courses, and let's say law is one of them, they can, basically do what they want when it comes to, the establishment of branches. And mind you, Central University, I think, was affiliated it was under mentorship to KNUST.
All right.
So I don't know whether they had, some arrangement with KNUST to establish the Kumasi campus, and then, have the supervision being done by KNUST.
A general observation, and I want the two of you to take give us a comment about a general observation, is where you find that the intake is more than what the facility can take, and so you find the recommendation requiring some of these institutions to reduce their intake by half. How does that impact on the quality of the product? Particularly in circumstances we are also informed there are no tutorials.
In fact, Samson, I wanted to pick up on the question of tutorials, when you gave me the opportunity. And I think my former tutorial assistant, or TA, happens to be on this program with me. Was our commercial law teaching assistant. And you can ask him, we used to be probably like between 10 to 15 students. So he had to take, of the 60 students who were, I think were 40. So he had to do about 4 or so, tutorials a week in order to cover all of us. All 40 of us were not in the same, tutorial group. So he had to divide us into, I think, 4. All right. Now, what that tells you is that 15 of us sat in front of him. He gave us assignments. We would turn in the assignments. He would ask us questions. We'll discuss the legal principles, recite cases. He would tell us all kinds of, things that we are not happy about. But it was part of the learning process. I mean, he was such a hard tax master. We used to be going into his tutorials with pounding.
I thought I was nice.
No, you were nice. I mean, you were nice outside of class. But something, the point is that this was a training ground, not only for understanding the theoretical underpinnings of law, but also for training in advocacy. Somehow you would not, appreciate it, but you have, a lawyer, at that time, Ace was a young lawyer, but he would, I think at the time he was left alone, and I don't know why, but most of the TAs would come into the tutorials with their lecturers. All right, so Professor Kumado will be doing, constitutional law tutorials with his teaching assistant. Now, you are sitting in front of a very senior lawyer and articulating legal principles, trying to convince him that you understand the principles, you understand the case law, you can apply the case law to a fact pattern, whether hypothetical or not, that is in front of you. That is a training in advocacy that you don't get, without tutorials. Okay, because when you have a large class and the lecturer basically is teaching, and then you can ask questions from time to time, it doesn't give you that hope. So for me, I was really, really, really shocked, okay, that you would have a law faculty teaching, students without having tutorials. That, I think, is, unpardonable.
Yes, even in instances where the teachers are overburdened, doing credit hours more than they can take. So, Ace, what's your take on that, and how that the implications of that on quality?
Well, the training, Dominic is right, and actually, I remember a young Dominic Ayine, very naughty in tutorials. I was young too, and even when you could tell he was winging it, he winged it very confidently.
Thank you.
And it was easy getting the best out of him, even in those days. There's no surprise what he is right now. But having said that, look, it's the quality of the teaching and the training, the entire training. The lecture is basically a lecture. The lecturer tells you what it is. But in terms of the tutorial questions, which are problem questions, essay questions, which are like precepts to the exam, which applies what you learned in the classroom to real-time situations and story problems, so you can think laterally, you can think on your feet, raise the issues and address them. You encounter that for the most part in the tutorial. That is not happening if you don't have tutorial assistance. But Samson, my point is that this is not a yesterday's problem. I spent 5 years at the Faculty of Law, spent a 6th year there as a teaching assistant, went away for just a year, came back 2 years later, or 3 years later, when I went to teach again, things were different. So I'm saying that the slide just didn't begin today. It's been going on, and Dominic is right. There are various reports that have shown that there's a problem, but we haven't addressed it. And I'm saying this is the opportunity. We have to address it. Look, I taught commercial law at the business school for 6-7 years. When I was appointed, I didn't receive a curriculum. There was no course outline. There were no preceding notes to refer to. I basically prepared and went to teach. My instruction was never audited. My teaching was not monitored. They just set the exam, let them write it, send it to us. And I made so much noise that when they decided that they had had enough of me, they didn't even tell me. The two of us just knew that after that year, I wasn't coming back, after teaching for about 6 or 7 years. So for those 6 or 7 years, I could have been teaching poison to the students.
Okay.
And nobody audited, nobody monitored. Sorry, I see you got to go.
Right.
Go to your
okay, so this must have been comments by Chief Justice Sophia Kufu, but what is the purpose of the publication, and what will it do to changing the circumstances, resolving the bigger problem that has been discovered?
Well, Samson, I think...
Sorry.
Yeah,
you first.
Okay, thanks. You know, I think the essence of the report is to show, to throw the light on the problem that we are having at the base. All right. So if you take legal education as a pyramid, all right, we have the law faculties as the base. We have, the professional legal education at the second tier, and of course training in chambers. And that is why we have pupillage, as a mandatory requirement let's say a third tier. All right. The report is important in highlighting the problems that we have at the base. And if you have problems at the base and the quality of the training at the base is poor, then you can be sure that coming up, whether at the professional level or when people are admitted to pupillage, right, the quality will invariably, be also poor. But that is not to say that you won't get some, excellent, lawyers filtering through. And, those are the ones that, my brother Ace and Co will pick at Base Angel, and then leave the rest, for the market, the market for legal services. The point is that this report tells us that accreditation is crucial, all right? It's crucial to the process of reforming legal education. And I think that the joint monitoring with the GLC is very, very important because for many years, the GLC was not interested in this. If the GLC had been interested, like the current CJ has, shown, then I'm sure that the problem that we are having, where the issues we are discussing now, would probably have been discussed earlier, highlighted, and resolved. Okay, but better late than never. And I think that is a good thing that we are having this conversation about the reform of legal education.
Let's hear Ace's take on this, and we should be wrapping up onto what this should mean to resolving the bigger problem and challenges facing legal education. Yes, Ace.
Okay, that was what I was going to speak to, so I'll just speak briefly. What I like about this is the recommendations. And actually, if you look at it, the recommendations were time-bound. So by now, the various faculties must have responded to the queries the General Legal Council and National Accreditation Board raised. So the question is whether they've received those and whether they answer these questions and the extent to which they go. But I have I think we should pay a lot of attention on the recommendations contained in it. But I have various, the ideas to put out, not just for the substantive law tuition, the faculty tuition, but dovetailing into the problem we have with the bottleneck that we call professional legal training, where we have 3,000 people waiting with law degrees who cannot practice law because law is the only degree which if you try to practice without a professional qualification, you end up in jail. It's an offense to practice law without a professional qualification and being called to the bar. And so we need to have a holistic review of all of this. We created the problem when we expanded to the 10 faculties without fully expanding the law school to take the numbers we're creating. And what we underestimated was the interest that was burgeoning at the time in the study of law. And it's social. They said the law program is a cash cow for a lot of the schools. Check the universities. The law degree is giving them a lot of money.
They were emphatic about that. They were emphatic about that for the Gimpa Law faculty, that the faculty was the cash cow of the school, and that was a reality that the school needed to resolve. And it cuts across that there is money in introducing the law program, and so for most of the faculties, they are just interested in getting the money, organizing evening classes that don't give you sufficient time to learn the law and to be able to pass the exams to enter into the law school.
Yeah, but so how do we leverage this? There's an interest. People are prepared to pay. And so a lot of the problems that are resolvable by money, like building the library, like training the lecturers, people have shown that they are prepared to pay the fees to get it. So the question is, what are we using the money for? And that will come into the recommendations section. Because, look, part of the problem we have with the quality that is presented to the law school is that for many people who turn 50, who see retirement at 60 in 10 years, in this day and age where you can't change your date by an affidavit anymore, they begin to look at, what am I going to do when I'm 60? Law then becomes the option. You do 5 years in school. A lot of these people do not have the time to attend Dominic's lectures because they are working. All they have is their annual leave, which they plan to coincide with their exam. So technically, they have 2 months. They photocopy the notes of people who have been in school and basically go to the exam room and wing it. So the question is that there's a problem. And look, whole issue about the entrance exam. I was around when this was evolving, and it was interesting. When the faculties expanded, the law school was so constricted. And so at first, they were looking at the qualifications. I'll tell you this. Some of the schools presented graduates with first class plus in law, so they could get into the law school. Then they changed it and made it a quota. The quota system didn't work. So they imposed what the Supreme Court has told us to be 2 illegal, now legalized schemes, or one is illegalized, of the examination and the interview, all as the way of sifting. But they were just dealing with symptoms. Samson, this report and the publication of it is giving us an opportunity to do a complete review from the faculties through the law school to determine how we want lawyers trained and the kind of quality that we want the lawyers to have. We can talk about this, sweep it under the carpet again, like the way we have treated some of Professor Kumado's report. And not 10 years from now, an older Dominic and I, grayer Dominic and I will be on your program. By which time you probably have lost all of your newly acquired hair, Samson. And we will be talking about these issues all over again. Right. But this is a great opportunity to fix it. And so the question is whether we are prepared to lance the boils and fix this. But when we come back, I have a few specific recommendations that I would like to make.
Okay, so if you can go ahead with the recommendations.
Oh, great. Well, 2 things about the quality of the tuition. A terminal, if we insist on a PhD as a terminal degree, we are going to, and especially when the schools in Ghana are not offering it, we're going to run into a problem. And it's not everybody who will go and get a PhD from Stanford and return to Ghana like Dominic. I mean, I wonder what's wrong with him, but they won't come back because there are other opportunities, right? And so we need to look at what we call a terminal degree. We can look at the LLM as a terminal degree. 1, a 24-month LLM that takes into consideration a full year of taught courses and a full year of dissertation, not dissertation, a thesis, not a dissertation, a full year of a thesis on the area that the lecturer, now because they are teaching without it, wants to operate in. So we know that if you are doing contract, it dovetails into business law, it dovetails into commercial law, agency, etc., etc. So we ought to be prepared to provide this, a thesis-based program but also one that is based on the taught courses, so that we will not accept a simple taught course. So if you know, a 9-month taught program, but you need to have written a thesis, because the thesis gives to the teacher writing skills, research skills that he or she probably did not get at the LLB level. Now, if it is not possible to provide that in the University of Ghana, this is what the schools that are making all this money can do. Get a taught program anywhere in the world, or in the common law world, for your teachers. When they do that LLM program in 9 months, let them come to the University of Ghana or whichever university and write a dissertation for a second LLM, if we can't get a 24-month LLM for them to do. So we can fix this. The faculty that are making the money will be tasked with training the teachers who are prepared to go through the training. Okay. So you take the taught program and you write a thesis. All right. Because the credit and a mandatory course in the Master of Laws program that Ghana will accept is a module, it's a course in legal education. Okay. Where you are taught how to teach law to students. That will build the faculty in terms of the baseline entry requirement. All right. The second one will be the curriculum itself. Yeah, we talk about books published in Ghana. How many? Look, if you have 10 faculties, you have 10 lecturers in contract law. What are they teaching? Bring them all into a week's training somewhere, Koforidua, Sunyani. Bring your lecture notes. There's a coordinator. What are you teaching in consideration? Which principles are you teaching? Which authorities are you supporting the principles with? Wait, this case you are using is old. There's a new one. So when the 10 lecturers are sat down with whoever the facilitator is and gone through their instruction manuals for a week, at the end of the day, we have a composite curriculum that is taught as the baseline in all the 10 faculties that we have in Ghana. Then you can build on it. Then it becomes compulsory material for every student who is entering any of the schools to acquire. It actually puts money in the pockets of the teachers, you know. All right. So you acquire it. It is a mandatory thing. Everybody has that baseline. Okay. Then you build on it. Every 2 years, they have that retreat where they build on the structure. And so, look, within 10 years, we'll have a comprehensive law trove to which students have access, whether it's on the school's website or it is on their PCs. They can read ahead of the class. So that you don't go to the lecture to read notes. All right. The students have the notes. You deliver a lecture on it, something. Okay. All right. Thank you. Thank you so very much, Ace and Kuma. And Dominic, what will be your recommendations to going forward? Ace just mentioned one very critical issue. If the insistence is that you must have a PhD in law before you can teach it, and the evidence shows that lawyers with considerable experience have taught the law in the best way and have produced the best of lawyers and even judges, and so the system has been better for it. Why that insistence, for example? So what will be your recommendations? About 2 of them. And why are we not closing down? Why are we not closing down those institutions that are at fault and producing the wrong numbers?
Okay. On the first issue of the terminal degree, I think I was a victim of that policy requirement at the law faculty. At the time I started teaching at the law faculty, I had just come back from the University of Michigan Law School with an LLM, and I was, hoping that I would continue just like my seniors, the other lecturers. Professor Kumado, for instance, excellent teacher, very knowledgeable, one of the best we have in the country when it comes to constitutional law. Doesn't have a PhD. Professor Mensah-Bonsu, now Justice Mensah-Bonsu, okay, a fantastic, scholar of criminal law, doesn't have a PhD. My lecturer in contract law, Christine Dona-Hammond, also fantastic and a fantastic intellectual, no PhD. So the insistence on this PhD thing has been kind of a bottleneck that we need to look at very critically. And I think Ace has done well with the recommendations that he's put forward. We need to think about it very carefully. Otherwise, it will be very difficult in the coming years to have young people brilliant people wanting to teach law because, most of them would not want to waste, or not waste as such, spend, say, 3-4 years, trying to get a degree from a foreign university. But I wanted quickly to say one thing about legal education. I have always been concerned about the professional aspect. Ace has hinted about the numbers. I don't know how many they are now, but we have about 3,000 odd students who have LLBs and cannot get access to, at the law school. I think that we have to begin to think, broadly about how we can deal with the backlog of numbers. Okay, because these are young people, our own citizens are aspiring to become lawyers. It's not their fault that they want to be lawyers. We need to find a way of dealing with it. I have always maintained that if the law school cannot expand in order to absorb all of them, we then need to think about abolishing the law school system and maybe go the American way, where you can take legal training, professional legal training down to the faculties. Of course, that is going to add to the problems that have been highlighted.
Dominic, why do you think these problems remain entering the law school? That problem, why do you think it remains, even when the people at the helm, people like the Chief Justice, who are chair of the General Legal Council, there are people in the Supreme Court, judges in the Supreme Court, including the Chief Justice, whose children did not have access, whose children have tried once, twice, or been successful only on the 3rd attempt. They are there, and yet they feel it, and yet the problem remains.
Well, I think that, it's possible that we are not, as a nation, or as a group, okay, I'm talking about lawyers, maybe we are not thinking out of the box, okay? Because if you have a situation where the CJ's own son, all right, is struggling to become a lawyer, okay? And you have sons of lawyers like myself also struggling to become lawyers. My young man, Ross, has taken the professional exam twice, and he's still, yet to make it. But I keep telling him that he's on his own. I came from Tongo Primary School and managed to become a lawyer. If you come and attend elite schools in Accra and you cannot become a lawyer, that's your own problem. All right, but we need to be able to, reform the system in such a way that intelligent students don't fall victim to a system that makes it impossible for them to get through. Okay, granted that some of the people who are roaming the streets with their LLB are not, your, typical above average students. Some of them you really don't deserve to become lawyers. Okay, we've had, encounters with some of them. The CJ himself was telling me that one of them came to an interview, and when asked what is meant by res ipsa loquitur, the student asked the interviewer, what does that mean?
Really?
All right. Now, for you to have an LLB, having studied the law,
you've done like 3 years, 3 years at LLB, and you don't know res ipsa loquitur?
Right. Yes. Yeah. You heard me right.
Okay. So that's very serious.
You didn't punch it in the exam.
And this was a CJ telling me, in front of Justice Yoni Kulendi, that this is what is happening. So if you have people like that, in the system, they don't deserve to come through to become, lawyers. All right. However, having said that, we need to think out of the box and maybe look at how we can either expand access, all right, and maintain the law school and expand access,
okay,
all right, or abolish it altogether. Take the professional training, back to the faculties as a clinical legal, a law program.
Okay.
All right, and then let everyone write a national bar exam.
All right.
And that, I think, is probably going to solve the problem for us. So, for instance, just a concluding thought.
Yeah.
Let's say
do that very quickly.
We now take civil procedure as one of the, let's say, the professional courses, a mandatory course, Ace could become the chief examiner for civil procedure for the national bar exam. And then he can recruit people like me as his, fellow examiners, who would examine civil procedure with him. So we have an examiners meeting when the civil procedure is written. We draw up our, a timetable. We mark the papers. We submit it to the General Legal Council or whichever body is in charge of legal education. And then the list of people who have passed civil procedure is published.
All right.
So I think that that's the way to go if we have to solve this problem of access.
All right. Thank you.
I wanted to add quickly to that, Samson.
Yes, do that quickly.
I wanted to add quickly to that, Samson, that is possible. That is possible if we get the national curriculum together. If the civil procedure lecturers instruction manual, that is across board, then you probably do not need the lectures in the law school to study for and write the exam.
All
but
right.
I wrote this recommendation to the General Legal Council. I'm not sure where it ended up. Probably in a trash bin. Same recommendation. But the issue then is this. If the faculties that one was going to trust to do this instruction are the ones we are saying today are not fit for purpose.
Right.
So if we don't do the root and stem reform from the faculty level, it's going to affect the law school. But we can do what Dominic is saying, but we need the national curriculum, the national instruction manual. That ought to be done ASAP. That's my final recommendation.
Thank you so very much, gentlemen, Dominic Ayene and Ace Ankoma. Thank you so very much. And we have heard the Chief Justice even speak about trying to have a national sort of forum that can, aggregate, brainstorm, and bring together ideas as to the way forward. And it does suggest that there is some light, at the end of the tunnel. Thank you all so very much. Kofi Bento sends me a message. He says, the report reveals that many law faculties are unfit to exist. A says unfit for purpose, and he says unfit to exist. Truth is, across tertiary education in Ghana, this is true. Many universities do not have what it takes to exist. So why are they still running? The clear reason is that the supervisors of that system, specifically the National Accreditation Board and analogous supervisory institutions, have woefully failed. If we solve that problem, wrong institutions will be closed down and good ones will be more patronized. Ultimately, the system will be stronger. This is failure of leadership. The solution will start from fixing leadership. And of course, as you read the report, you realize that Mount Crest University, KNUST, various other universities have made remarkable improvements over the time, whilst others are deteriorating. So this is really good. Thank you all so very much. And we...
But a quick one. The nuclear option is not always the best option. Mount Crest had problems. It was pointed out to them. They were not shut down, and they have shown how to fix it. There's a few problems left. But Mount Crest is the example of how to fix a problem.
Right.
So I won't go for a nuclear option. Immediately close this down now. How do we fix it? I think that's a better approach.
Thank you all so very much.